do you have any tips for witness handling?
I would say, again, it comes back to the adaptability point, but expect the unexpected, because witnesses don't always follow logic, for one thing. And if, especially as a cross-examination, you have no idea what might come out of them. So I find it helpful to think about lots of alternative sort of case scenarios. And that way you can, be ready as much as you can be. And also, in terms of how you actually ask the questions of them, as much as possible, and really ought to be always, ask one question at a time. So not having two-part questions, because inevitably what you'll have is a witness who will either get confused about the question, or they'll forget to answer part of it, and it's really awkward going back and you just look a bit more mismanaged. So ask very simple questions where there is pretty much only one way it can go, and then be ready for some bonkers answers and adapt. So if you have your 10-page or whatever list of questions, as Callum suggested, then you might be in some trouble if you don't know how to progress from one stage to another if you get a weird answer. So that, again, adaptability, I think, definitely happy with my answer I gave earlier on that.
Excellent, thank you, Alice. Anyone else want to jump in on cross-examination?
I would just say that for me, the most important thing is control. You've got to have control of the witness, and particularly with cross-examination, when it goes wrong is when the witness starts taking control of the exchange and saying what they want to say and going off and talking about what they want to talk about. So you just got to be confident and robust and say, no, stop there. I'm not asking you about that. Or even simple things that aren't very confrontational, but very powerful, such as if you ask a simple question like, it was raining, wasn't it? And they then give a long rambling answer. And then you just look at the judge or the jury and, as if to say, they haven't answered that question, have they? And then just ask the exact same question again, because that just makes them look like they're being deliberately difficult and not doing what you're reasonably expecting them to do. So for me, in cross-examination, it's definitely about control. And that's probably true about examination in chief. You don't want to, you obviously can't lead, and I'm a personal injury practitioner, so I have the joy of just saying, well, if your name's still your name, that's your witness statement, and we don't need to worry about that too much. That was your solicitor who sorted all that out for you, so I can just do the fun bit, the cross-examination. But I still think it's about control. You don't want to be domineering, but you need to get out the evidence that you need to get out. And whether you're going through a witness statement, ticking off bits as it's coming out, or you've got a list of what needs to come out, you need to have sufficient control of the witness to guide them where they need to be.
Know when to stop. I think is the biggest piece of advice I'll give anyone, because a lot of people fall into the trap of asking just that one too many questions. And what it does is give the witness the opportunity to give the answer that they actually wanted to give to what you may have carefully cross-examined previously. So when I'm teaching, I say to students on the bar course, I say, think about, you've got a little bag and you're putting your points in your bag. And then once you've got your points, sit down and shut up. No one wants to hear anymore. Yeah, that's it.
The great Irving Younger, an American judge who was fantastic on advocacy teaching, he said a particular phrase which I took to heart, and so I apologise in advance for the semi-swearing. He said, "Never miss an opportunity to shut the F up." And I think that's a great one question you should always be asking yourself is, have I done enough? Have I got what, have I done enough? When can I sit down? When can I stop? And this comes back to preparation, because it's so tempting to put every point to every witness and to sort of get every piece of evidence out there. But one question you should always be able to answer immediately is, why am I here? What do I want? And that can, whether that's in a global level, like, I am here to secure an acquittal, I'm here to get an injunction, or even I am just here to leave court with some directions we can actually comply with. And do that with each individual witness, because a lot of the time, when if you've thoroughly done your case preparation and done all the things about, working backwards, what do I need to be able to say at the end of this trial to win it? And what do I need to be able to say that? You might say, I actually only need one piece of information out of this witness. You know, that's the only thing I need to do. So, you know, you'll have your different techniques for controlling a witness, like, you know, you might have some simple questions to put them at ease, or to, you know, gently ease them into something, especially if it is cross-examination and they're, you know, you're the opposition, I'm scared. Because a lot of the time, you don't need to be that hostile. You know, it might be that it's something that's relatively uncontentious, and, you know, you're not trying to trip them up. But yeah, I would always say that just work backwards from your brief and just really, really narrow the focus and just concentrate on that issues with all the classic things like very tight, you know, control questions. And don't forget, ultimately, if a witness completely goes off piste, that's the judge's job. And sometimes, you know, as Jamie was just saying, sometimes you just have to sort of look at the judge. You know, you'll ask a question, you won't get the answer, you'll put the question again, and then you just look at the judge. And it's for and then the judge can step in and say, could you please just answer the question?
Good pointers there. Anyone else got any comments on cross-examination at all?
I think you have to understand the type of witness that you're dealing with, because you can't deal with every witness in the same way. So if you're dealing with an expert witness, that's obviously very difficult, very different from a lay witness. A young, vulnerable person, or a person with some sort of mental health issues or learning difficulties, has to be dealt with differently. Certainly in the criminal courts now, where we have Section 28 examination and cross-examination in advance of the trial, where you're having to set out your questions and have them approved by the judge, and then it's videotaped and then played at the trial. That can be very difficult if you want to ask a particular witness a particular question in a particular way and the judge is saying no, or an intermediary is saying no. So I think you have to understand who your witness is in terms of what type of witness. And what I would say in relation to an expert witness, one of the benefits certainly of criminal law is that we are learning, certainly I am learning new things every day. So if a case deals with gunshot residue or deals with bite mark injuries or whatever it may be, you unfortunately have to become an expert on that topic, because if you don't understand it, it's all very well having your own expert. If you don't understand it and the witness tries to go off piste, then you are not going to be able to deal with that witness and you'll lose the point. So it's not just about the case, it's about reading around whatever that witness may be saying. If a witness says this thing happened in a particular area, you either need to have gone to that area, you need to have looked at it on Google Maps or on Street View. You need to be able to say, well, you said this, but, you know, there is a telephone box, or there is, you know, a big tree in the way. So it's not just about asking the questions based on the witness statement. You need to do more in order to prepare for it.